I have been doing community association law at this firm for 20 years. It just feels like 100, but I love it. Our firm helped write a lot of the community association laws back in the early 70s with the creation of the Condominium Act. And we still help try to write laws with the legislature every year through our legislative arm and our leadership lobby, because we know that associations need all the help they can get with the legislature because the contractors and the banks don't want to give you the rights that you deserve. But that's for another discussion. I do like the banks that want to lend you money, and that's what I have here today, which is John Telfer is with me from Association Prime. And John, I'm going to let you introduce yourself because you're the guy that gives the money away. I like that. So go ahead, John.
Thanks, Scott. Yeah, my name is John Telfer with Association Prime. We're a division of South State Bank, formerly Center State Bank, that you may be more familiar with. We just had a merger of equals about 2 months ago. Our division is carved out. As you know, association banking is its own unique line of business. And so we have carved it out where we only handle association banking, from lending to deposits, software integrations, anything that goes with that entity. And we know the importance of issues that come up in this industry. One of the things we're known for now is, we're an aggressive lender, meaning that, we will look at every deal for you. And, our really value add here too is that we don't like to say no if it doesn't fit in the risk layer, if somehow. We like to try to find someplace you can get that money for your association. So, we're in 6 states, but we operate nationwide. And, any questions you have at the end, look forward to helping you with anything.
Thanks, John. And John, feel free to jump into my presentation here, especially if I start talking about banking stuff. If I don't know what I'm saying, feel free to correct me if I'm wrong. So listen, just want to tell you folks that Becker we have more board certified construction lawyers than any law firm in the state. We're a statewide firm. And what that means is that the Florida bar says that you cannot call yourself a specialist or an expert in an area until you become board certified. So we definitely have more board certified lawyers in many practice areas, especially community association law and especially construction law. And the point of that is that's because we want to be a specialist. We want to be experts in these areas. So education and training is at the forefront in this firm. We want to make sure that we've seen these angles before we get them to you. And we're pretty busy in our construction department now because, as you can imagine, everybody's rushing now to get these restoration projects done, these concrete restoration projects or other projects, which I find odd because, engineers have probably been telling associations for a long time now that you have to get to work on these projects. And, when a client asks me, I've got a ton of new contracts coming in the last couple of weeks, which is great. It's good to see projects getting off the ground. But when a client asks me, well, what are we supposed to do? Well, what is your engineer telling you? I don't have an engineering license. I'm not trained as a professional engineer, so we have to rely on these folks to tell you what you need to do to get your construction project going. I can't tell them. I know what the Florida Building Code says, but I'm not the person that is the ultimate responsibility for signing off on construction plans. So let's talk a little bit about construction projects and some things you need to look out for. This presentation, I'm going to try to speed it along. I've done this before. There's a lot of slides here that I'm going to skip over because there can be no more confusing. And there's actually a case where a judge says this, that there can be no more confusing statute in Florida than the construction lien statute. So I'm not here to, give you a minor in construction law because it can be very convoluted. I'm here to tell you what the takeaways are that you need to be looking for in your project. So just, from the outset, one of the big things is we have a lot of associations in Florida that tell us, well, we just really don't want to pass a special assessment. We don't have the money to deal with this project. Well, what a lot of associations don't know is, I understand that. People are on a fixed income. They don't want their assessments to go up. You can take out a loan. A lot of banks, and John's bank specializes in giving loans for these construction projects. And it allows you to pay it back over time. So that's really important to know, is that your bylaws, and we'll talk a little bit about that, probably talk that you're allowed to borrow money. You're allowed to buy property, borrow money, enter into contracts. These are all things that are in the bylaws. But I get a lot of associations that will send me a contract and say, hey, we've got a little problem with this construction contract. Can you help us out with it? Well, did I review it? Was I given it? Is there protections in the contract that I could have put in there early? It's hard for me to fix a 1 or 2 page proposal for $300,000-$400,000 that you've signed off on that has you going and litigating in Pittsburgh, or that doesn't give you a warranty, or that doesn't give you an additional insured because they damaged a unit owner's property. I can give you these protections if I'm able to look at the contract early on. So contract formation, the best opportunity to protect yourself is having the contract reviewed before it's entered into, before the formation of the contract is executed. We can write anything we want in there. If there's something that the president or the secretary really wants to see, we can put it in the contract at the formation. So that's why I'm always big on, can you send me the contract before you execute it? And I get it. I get that you don't have a ton of money for this project to be paying the lawyer, but it's a little surprising to me, and I'm just going to be frank, that you've got $500,000, or even I've seen $2 million restoration projects where they come to me and say, hey, we really don't have any money for you to review the contract. Really? You don't have $1,400 for me to like write an addendum to this contract, but you're spending $2 million. And by the way, you're probably going to have change orders that's going to increase it over that. So, I mean, tell me what your budget is early on. I'll tell you, look, I can review part of it. I can give you a couple of boilerplate protections to stay within your budget. What I would prefer to do is rewrite the whole contract. But I can tell you now, contractors, they don't want to take it to their lawyer. Their lawyer's going to say, no, the contract's fine. Let me just do a small addendum on the back of the contract, something to give you a few more protections. So a strong addendum, which is a 1 or 2 page addition to the contract, can really help you later in the contract. Here's the type of contracts you're going to see: lump sum, unit price, or cost plus. I want to see the lump sum. Tell me exactly how much this project is going to be. And even in that lump sum, I can get a lot of protections. So it just provides you with the most protection there. It gives you the exact price, what contingencies are included or not included. Have they checked the plans? Have they confirmed the local site conditions? Again, a lot of these contracts that I see, they don't have this language in there. And so I want to put on the contractor the full burden that you've looked at the project, you've examined the scope of work, and you are agreeing that you can get this done in this price for this lump sum. So a lump sum is a great contract because it has the full amount in there. A unit price, we see these sometimes on concrete restoration, where the contractor's like, look, I don't know. I don't know what I'm going to see. I don't know what I'm going to see when I start chipping away the concrete on the, these beachfront condominiums. They start chipping away the concrete because they're doing the restoration, because the rebar, which is the steel that holds the balcony in place and holds the concrete in place, is rusted from years of salt air exposure. So the contractor doesn't know how much rebar is going to have to be replaced until they start chipping away at that concrete. And so that's fine to do a unit price. Basically, the contractor's going to say, I'm going to charge you, $50,000 a unit or $20,000 a unit plus 10% profit, 10% overhead. Those are fair contracts. I'm not a huge fan of them, but I'll try to get a unit price whenever a lump sum whenever I can. And you should be looking to get a lump sum. If you get a unit price contract, you definitely want to have your law firm review that. I'd be happy to review that for you. And sometimes I make it a little more difficult for the contractor to accept the addendum that they're just willing to go to a lump sum contract. So, but unit price, if it's adequately defined, is acceptable. Cost plus, I'm not a fan of these either. They agree to do it for a cost plus labor, materials, subcontractor fee. It gets out of control. It's just the contractor has so many different additions added on to to a cost plus contract that it just makes it almost difficult to work with. And the contractor will change order you to death on a cost plus. There's a big yacht in Miami that's called Change Order. And it's it's for a reason. The contractor's best friend is a change order. They come in and they tell you they can do the contract for $1 million, and you end up paying $2 million because of change orders. And we don't want to see that. We want to have all the protections in the contract, right? So we want to have the best ability to avoid that is contract formation right up front. Sometimes you can't avoid that, and it is what it is if you can't. Let me try to fly along here a little bit. Let's not talk about cost plus anymore. Standard form contracts, all right? There's no such thing. I mean, all of the construction lawyers that I work with in my firm, we don't even like the AIA contract. The AIA is going to be your most standard contract, the American Institute of Architects, and they say, oh, well, it's a collaboration contract dealing with a committee of architects and owners and engineers. No, it's not. It's a contract that's contractor friendly. We'll accept it, and I can do an addendum changing a lot of the things in the AIA that are not owner friendly. So I can work with it, but if I get to, what I would prefer to do is if you come to me when your engineer is doing the scope of work, I can give you our contract, and that can be put in the bid proposal. It's because we rewrite the whole contract. We have like a 25-page contract that we write up front. A lot of times it's too late for that because you're getting the contract from the contractor and you're asking us to review that. So at that point, all we can do is an addendum. So there's a couple other, there's another contractor out there from the engineers, a contractor out from engineers, but that's not a very good contract either. So your standard form contract, there is no such thing. If there is, it's going to be an AIA 101 or AIA 201 or 104. And those we can work with. If you want to send those to us, we can review them. And again, I can stay in your budget. I'd rather fully protect you, but let's talk about how we can protect you with the budget that you have. The meat of the contract, again, this is, it's not rocket science here. We need to see in the scope of work exactly what's being done. And this is where I think your engineer or your building consultant who should be working with you on a larger contract can help you create a very detailed scope of work. Okay, I hear this all the time. We don't want any subcontractors on the job. We just want the contractor that we hired. That's unrealistic. And there's not really, the reputable contractors out there now, they all use subcontractors. And so the only thing that we can really do is make sure that there's protections in the contract for these subcontractors, that they are going to, in fact, be used. And if they are, what are the rules that we're going to require for the subcontractors? And again, this is just a slide. I want to show you how you can take care of your own means and methods. And, sorry if I'm rambling too fast. There's a lot here. So feel free to call me afterwards if you want. Happy to talk with anybody about this. I'll bore you to death with all the construction knowledge I have. But okay, so a consultant. Let's talk about that. For the best thing you can do for your job is, one, have me review the contract, or any of your lawyers review the contract. But two is you need to have a consultant. And what I would recommend is an engineer, a professional engineer, especially on the larger projects, or a roofing consultant. These people can do a lot for you. Now, I know, they may charge you anywhere from 5 to 20 to 40 grand for a project, depending on the size of the project. But it's going to be money well spent. I mean, it amazes me how many times I'll see people spend $1 million on a contract for the community, but they won't spend another $20,000 for a consultant. This consultant is going to be your eyes and ears on the project. I'm sorry, but I'm not able to go up and see if the pour is exactly right on the concrete. I'm not able to go and make sure the nail pattern is correct on the roof. I'm not able to see how far the flashing or the reverse flashing comes over the stucco or under the other flashing. An engineer can do this for you. A building consultant can do this for you. A roofing consultant, any kind of consultant that's a specialist in the area can do this for you. And they'll approve the applications by the contractor for payment. They'll do the periodic inspections. I've seen good engineers tell a contractor, I'm not signing your pay application, which is a form that they give to you to get paid for all the periodic work they do. I've seen engineers say, no, you got to go back and redo that roof. All of your shingles on here have bad nail patterns, so we're not going to sign the pay application. I mean, don't put that burden on the board. Don't put that burden on yourself. I mean, I'm sorry, but last time I looked, an LCAM doesn't have a professional engineering license. So why put that burden on you and use your own engineer or consultant? I would rather you not even have me spend the money on reviewing the contract if all you have is enough money for a consultant. A consultant is even more powerful than a good contract sometimes, okay? So I really like when people use the consultant. Again, here's what I hear sometimes too is, oh, we don't need a consultant because the vice president's a retired contractor. Really? Okay, so that's where we're going now. We're gonna use their brother's sister's cousin to oversee the work. Don't do that, folks. I mean, get a professional, properly licensed third-party consultant. By the way, I'm going to do an addendum to the consultant's contract too, because I'm going to put the burden back on the consultant if there's leaks afterwards. Because again, why not? Why not have an arm's length relationship with all the proper professional people that you can have on the job? Okay, here's other ways that you can protect yourself. Like we talked about, a good contract, a good consultant. Here's another way. In the contract itself, we need to see proper language for insurance. And here's another protection, a payment or a performance bond. Okay, a bond can be expensive, but if you've got a job that's $1 million or $2 million, it's probably going to cost you an additional 7% for a bond. And that may seem like a lot of money, but I'll tell you the distinction between a bond and and insurance. And then we could talk about indemnification too. Again, you can never have enough insurance. The contractor's going to have a liability insurance. They're going to have an errors and omission. We may even be able to get them in my addendum to get an umbrella policy when the liability policy isn't enough. A completed operations policy, meaning that if there's defects later, we can go after their insurance for that. A builder's risk policy, meaning if all of the shingles or the wood on the project are stolen overnight, that covers that. Again, auto, flood, I mean, you can never ask for enough insurance. And a lot of times on these insurance policies, I ask that we be named, the association be named as an additional insured. Because if the contractor's hammer falls down and on someone's car, and that person sues the association, I want to be able to say, whoop, we're not using the association's insurance. We're an additional insured under the contractor's policy. Mr. Contractor, you caused this damage. Tell your carrier to pay up for the damage. It's that easy. Okay, so bonding, a performance bond. I hear a lot of times people say, well, the contractor's bonded because on the side of their truck, it says licensed, bonded, and insured. That's not what that means. That just means they have a bond in case they steal money from your property. A performance bond is actually different than insurance as well. Insurance only covers if the contractor causes damage. If they cause a leak into a unit, their insurance covers that. If they cause any kind of damage to the property, or if they end up hurting someone, that's what their insurance covers. And even then, we have to get additional language on their insurance to make sure that we're covered as well. A bond, what a bond does, a performance bond, they actually come in and say, okay, if the contractor doesn't finish the job or they don't do it correctly, we'll come in and do it for you. Because insurance does not cover defective work, believe it or not. Now, I'm very good in my construction defect cases, getting the contractor's insurance to cover the defective work because I use different cases to rely on. But as a theory, in construction defects, the insurance doesn't cover the defective work, but it does cover damage to other properties. So what we say in our construction defect cases is, which by the way, we do on contingency, and why would you ever not pursue for a construction defect? I see a lot of associations, not to get off on a tangent, but they go through with a painting contract and they have stucco that's falling off the building and the building's less than 10 years old. I'm like, why are you repainting? You should be suing the contractor for a defect and getting that money back so you don't have to pay, the owners don't have to pay for this project. But anyways, a bond, a performance bond will come in and will take over the job. Now they are expensive, so that can be a game time decision that you can rely upon. A payment bond, it's a little bit different. A payment bond is a lot less money, and a contractor may offer you one, and just ask them how much the price is going to be to add on to the contract. That just means if you get liened from a subcontractor, or the contractor decides to lien you because there is a dispute over payment, that it doesn't go as an encumbrance against the property, which is what the bank's not going to want to see, by the way. If they're loaning you money, they're not going to want to see a lien against the property in the middle of the project. But if you have a payment bond, it automatically attaches to the payment bond, so there's no encumbrance against the property. That's a fancy thing to have, but it's again, a belt and suspenders approach if you can get one and you can afford it. Indemnification, I could talk about that for hours. We just make sure that we have special indemnification language in our contracts and in our addendums that says that to the extent that we are going to get sued for something the contractor did, you got to indemnify us. And I attach all of that to their insurance. I attach all that to their additional insured. So let's not talk about the monetary cap. I'm going to skim over that, or the value. You don't need to know all that. You just need to know that indemnification is language that needs to be carefully analyzed in the contract to make sure that the association, its agents, directors, officers are indemnified for anything that the contractor does. Now, you're not going to be indemnified if you were a contributing cause to it, but how many times are you really a contributing cause to a construction project that's gone wrong? You're not. So we need to make sure that also we have proper indemnification language where the contractor indemnifies the association, its owners, directors, and everyone else for any acts that it causes due to its own negligence or intentional tort. So kind of fast tracking here. I don't know how much time I got. I don't really care. Everybody loves to finish early, but I got a little bit more to go here. Alternative dispute resolution. Here's another thing I do in the contract. A lot of these contractors, especially the big ones, they want to go to arbitration if there's a dispute. If you want to sue them because they did, defective roofing work out there, or their paint sucks, or whatever they did on the job that they did poorly, and we got to go and sue them, or at least threaten to sue them, they say, well, you got to go to arbitration. I'm getting rid of that in the contract right away. I do not want to see an association go to arbitration. Why? Because it costs $5,000 just to file in arbitration. Okay, no, we're not doing that. It only costs $300 for a filing fee to file a lawsuit in St. Johns County or Duval County. I mean, I'm sorry, but we're not going to arbitration. And then you got to pay for the arbitrator's time. That's another $5,000. So you're 10 grand out just in the cost alone. So I strike that right away. And if I ever see arbitration in a contract, that's gone. I would much rather take your chances with a local county or circuit court judge who actually wants to take care of the owners in their community. I mean, there can be no bigger investment in your life than the one that is your home. And you deserve to have all of the protections that you can get. Mediation, I'm a huge fan of that. And I make sure that that's in the contract. And the only thing that means is, hey, before each party runs off and spends money at the courthouse on me or opposing counsel, let's go to mediation. Let's go to a room where we get a neutral third party that can hear each other's dispute about the work that was done and see if we can come to some compromise. Most cases, most lawsuits are resolved through mediation. I know in our construction defect cases, like 95% of them are resolved through mediation, which is just where the insurance company and the contractor and the board all gets in a room and tries to work it out and see how much money they can get from the contractor's insurance company for the defects and deficiencies, which can be very successful. We have been very successful in mediation. Okay, the lien law. Here's where it's going to get really confusing. So I don't want you to get hung up on this too much, but its only purpose really is to protect the contractor and the subcontractors and suppliers. Because if they go out there and they do work on your job and you don't pay them, sure, they can sue you for breach of contract, but it's hard for them to really have the leverage rather than a lien. A lien gives them a lot of leverage because then they can foreclose on your property and they can take your property. Now I put on there that you can pay someone actually 2 times for the work if you don't get a proper release of lien. And that's where we want to talk about the subcontractors, and I'll get into that here. A notice of commencement talks about this is where you see on a project at the beginning on any large construction project, there has to be a notice of commencement recorded. Even on our addendums in my construction contracts, we make sure that a notice of commencement is recorded. It's required. It just tells where people need to send their intent to lien information, their bond information, their demand letters, anything like that should be on a notice of commencement at the start of a job. Okay, a notice to owner. Here's what this is. So the contractor has gone out and they've hired all these subcontractors. For example, you're putting a new roof on. I can tell you right now, there's probably a 75% chance the contractor is taking your money and hiring a subcontractor, another roofer, to do the job. So what this other roofer does is they send you something called a notice to owner. And this notice to owner is just saying that, hey, we've been hired by the contractor and we don't have a contract directly with you, association, but were hired by the contractor that does have a contract with you. And just know, to the extent that he doesn't pay us, we can put a lien on your property. So you're on notice now that if you pay him, you need to make sure you also get a release from us as well. And they have to serve that within 45 days of them doing work on the project. And I've actually seen that where a notice to owner wasn't served, and I've had a lawsuit served on me by a subcontractor, and I moved to dismiss it immediately and get sanctions and our fees because they never recorded a notice to owner. So if a subcontractor wants to be paid and wants lien rights, they have to do a notice to owner, and it has to be specifically served by certified mail or overnight mail, and all that information will be on the notice of commencement. Okay, so progressive payments, don't worry about that. Just make sure, the only thing I want you to take away from this is if you get a notice to owner, I want you to keep a little file of those notices. So when you pay the contractor a progress payment, you need to ask in exchange for a release from that subcontractor for that payment, because the contractor will take the money and they'll go out and buy a boat with it, and then they won't pay the subcontractor or they'll leave town. And believe it or not, it even happens with the big, large companies that they're trying to get ahead of the game and they're trying to pay their bills and they don't pay their subcontractors. You need to know that that subcontractor, if they give you a notice to owner, they have to be paid and you have to get a release from them. And what I'll ask from the contractor in these situations is I'll ask them for an affidavit. I need a final payment affidavit on any sub that may be owed money on this project. And we don't give that check until we get releases from all those subcontractors. Again, final payment, we need to make sure that all the work's completed, and your consultant can help with that. The warranty period, the waiver and release of lien from the contractor and any subcontractor. That we need a final affidavit and release of lien from every sub and from the main contractor too, when we're going to make that final payment. So this proper payments talks about this, and it just goes, I want to skip over this because I don't want to take a lot of time with it. It just talks about how things like, if you want to give a proper payment to the contractor, you need to get a proper release in exchange for that. And the contractor's final affidavit is a document that we can give you, and it's easy to get the contractor to fill it out. And that's a huge way of knowing which subs are owed money. Here it is right here, contractor's final affidavit. So a claim of lien against, this is very specific. I mean, sometimes a claim of lien is served. Just know that it has to be served on you within 15 days after it's recorded. And also, a contractor cannot put a lien on a property unless it's done within 90 days of their last day of work. And a lot of times we'll get a lien that's invalid and we can move to for sanctions on that lien. There's ways to do that. So, excuse me, 90 days within the last day of work is the time frame for when a contractor can put a lien on. And again, we can do a notice of contest of lien. We can do an order to show cause. So there's different ways that you can challenge an invalid lien. Also, a lien has to be foreclosed within a year. That's just like an assessment lien. So a lien must be foreclosed within 1 year, or it's automatically off the encumbrance. I've had banks call me John's probably had this situation where they need to see a lien be removed from the encumbrance. So I'm like, well, the lien's more than a year old. It's no good anyway. So it's almost void at this point, but we still want to get the contractor to record a release of lien whenever they can. I don't want to get you in a situation where you even have a lien, but I do see some contractors' lawyers get really aggressive. And if they get up on that 60th day and they're not paid because there's a dispute with the consultant, they'll put a lien on the property pretty quick. So we need to try to avoid that. And the contractor's final affidavit, it has to be delivered to the owner within 5 days of them filing a foreclosure on a lien. I don't want to see a foreclosure. We have seen invalid liens, and our defenses to those are that, sometimes a contractor can only put a lien on a property for the work they performed up to that point. They cannot put a lien in the middle of a project for the entire value of the project. That's an invalid lien. So we can use that to get damages from them if we ever get into a court situation over it. Again, we don't want to do that. Let's go to mediation. Let's get our consultant out there. Let's have an on-site meeting. So we don't need to talk about the defenses to a lien foreclosure. Just know that if they try to foreclose and they got an invalid lien, we're going to wipe the floor with them, and we're going to get your legal fees back too. And it's a fraudulent lien. You can get damages, punitive damages. So a contractor can say, I'm going to slap a lien on your project. Well, it better be a correct lien. It better be recorded in the correct county. It better have the correct legal details. I mean, it can be something that we can really pounce on them for. Again, you don't need to know this, but here's your options to avoid a lien. So we don't need to get to that point. If we have a good contract, a good consultant, and you have a good bank on your side too, to also make sure that you're going through all the proper protections that they want to see as well. Okay, so listen, let's take out a loan for your project. I see people say, we don't want to pass a special assessment. You don't have to. You can take out a loan. And guess what? You can probably take out a loan that won't have to be paid back over a period any shorter than 10 years. I mean, it depends on the size of the loan, but I know for a fact that, if you need to stay within a budget where the owners just cannot afford a $25,000 special assessment, then fine, take out a loan. I've seen it happen. It's becoming much more common, much more frequently, especially over the last couple of months. Your governing documents talk about when you can borrow money. We can give you a letter of authorization, or I forget what it's called, but we give a letter to the bank about their ability to loan. Sometimes banks call it, okay, can we get a lender letter just telling us that the association has the legal authority to take out a loan? We can do that. It's not that hard. It's, you can, when you're evaluating your project, I see a lot of people send me a contract sometimes and they'll say, like, today's Thursday, they'll say, hey, can we get this back by tomorrow? No, you can't. I mean, give me a break. Come on. There's a couple of people right now that are freaking out because they can't get a roofer to do the job. And, they're saying, well, you didn't get us our contract back in time. Give me a break. I can turn it around the same week. But a lot of times you're just going to have to wait on the roofing materials, when the roofer can start, when the concrete restorer can start. So make sure you have your funding lined up. Make sure that you have your proper reserves funded, because the bank's going to want to use some of that as collateral, and the assessment power is collateral as well. I believe that's pretty common for a bank to ask for collateral for their ability to come in and assess if they don't get paid. But the terms of the loan usually are very negotiable and they're very reasonable. I know that that's something that I've seen in every loan that's been taken out, at least this year.
Yeah, Scott, generally with the loans, it's going to, the terms are going to be based upon the project and what you're doing. So the loan doesn't outlast the life of the project. So,
Okay.
A painting project, you're probably 24 months on, where a restoration project or something of larger magnitude, those terms go out further and further.
Okay.
And one thing I would always tell a board is, in this environment, get a fixed term rate. Don't have an adjustable 7-year adjustable rate or anything like that resets for you to get a longer term. Rates are so favorable right now. Know your liability long term and lock it in for the longest period as we can offer.
And I believe the next slide talks about that. You can you want to consider the term length, the rate, the fees, the processing time. You know, there's all kinds of considerations. I probably am not the best person to even be, you know, we came up with this PowerPoint here on the lending, and I'm probably not the best person to talk about that, but I can just tell you that it is the people that have taken, the associations that have taken out loans are actually much more pleased because they can control that much more than having to make a special assessment. And just telling your owners that, hey, we're going to avoid a special assessment because we're going to get a loan and we have a little more time to pay it off. It sounds a lot better than saying special assessment. You know, sometimes you can't avoid a special assessment, but you know, at the end of the day, there's the ability to take out a loan too. So, you know, these are obviously you want to find the right financial partner, but I think you'd be a fool not to consider Association Prime here today, because I know that they can get it done for you and give you reasonable terms. And, you know, this could be a relationship that you could have later as well. Once you pay out this loan, hey, that went so smoothly, let's continue to do some more work on our property as well. Because again, it's the fiduciary duty of the board to maintain the property. And if they've been kicking the can on major projects or things that need to be done, well, now's a good time to point to a reason why things need to be done. And no more kicking of the can, especially if your engineer's telling you that it's time to fix it. So again, these are just some of the things that we offer. Resources, we're big on education. I can come and speak to your board. We have a ton of lawyers that can come and speak board certification courses. We have different blogs here. We have the call, our legislative arm. We have our construction authority where we have articles. I like to tell a lot of clients, like, you don't even need to spend money calling me for questions. You can just go on our websites. We have a ton of websites where we have free education and training. I mean, you know, it's amazing to me why people don't use those resources first before calling us, but I'm easy to access. I mean, I give you my cell if you want my cell. You can tell me, hey, I got a meeting tonight. Yeah, you know, we don't use Becker to represent our association, but I'm just wondering, how would this work if we did this construction project? I'm fine answering any type of esoteric or hypothetical questions because I know how it is. I mean, it's tough. But the one thing, the takeaway from today is definitely don't be afraid to borrow money to get a project done. A project has to be done. It has to be done. Either it's going to be done from a special assessment or from a loan. Use a loan if you need to. And again, the other takeaway is get a good contract, please, and have the necessary protections in that contract. That I'm willing to work within your time frame. I'm willing to work within your budget, and do what I can to get you the proper addendum or the proper revisions to the contract. And 3, please look for a consultant and when you can. If you need a recommendation on a consultant, I can give you 2 or 3, the good ones up in the Jacksonville area. That's really all I have. I don't know if I went over. I don't know if I went under. I usually just start rambling, which I'm very good at according to my kids. But I think at this point, I'm going to stop the share. And yeah, there's where you can find me, but I'm easy to find. Right now I'm in the Central Florida office, but I'm oftentimes up in North Florida. I get more work done in my car these days than I do in the office. So I'm pretty easy to find. Is there questions here that we should look at? I see one here. Would you please discuss the purpose of the notice of commencement and notice of termination and the board's responsibility? Again, the notice of commencement is legally required in the law, and it's supposed to be placed on a conspicuous place on your project. And it just talks about where people can see the contractor's name, the bank's name, if there's any lending information, the bond material in there, and or bond company's name. And we've even put our name on the notice of commencement. And the county requires it so they can know when a job starts and when they need to also permit the job, and then when they also need to close out the job for final completion. Notice of termination is commensurate with a notice of commencement, in that the project is terminated. I've seen notices of termination not happen on jobs. It's not a deal breaker, but it should happen at the end of a job after the the inspector from the municipality having jurisdiction clears the job. And the board's responsibility is just to make sure that the notice of commencement is recorded. The notice of termination, I'm not as much hung up on, especially if there's the inspector is signed off on the job. But the notice of commencement is a big one. And the board just needs to make sure that there is one from their contractor. Let's see, what should you get at the end of your job? At the end, when you are notified by our supplier or contractor acquired materials for the job and the supplier filed a notice and sent you a copy, you need to get a release from them, a release of lien from that supplier or subcontractor. Otherwise, you paid the contractor, you may go back and pay twice because you're paying the subcontractor to avoid a lien. You need a release of lien from any subcontractor that gave you a notice of owner. How important is it to have a consultant engineer help with the scope of work? Extremely important. It's very important that you, now if you've got a good roofer that's like, okay, we're gonna do a scope of work for you, and then we're gonna give it to you along with what it's gonna cost. That's fine, but I still think it's more important to have an independent third party look at that scope of work or even help you create that scope of work. So again, I would pad into any major construction project, I would pad in there the cost of having a consultant or an engineer create the scope of work for you to send to the contractor to bid out. So it's extremely important. You know, this isn't a vacuum. You can find John pretty easy. You can find me pretty easy. You got our emails. I'm on the web page. You can call Becker and find me. I can give you my cell. I'm not hard to find. And I'm also up in the Northeast area quite a bit. If you just want to come and want me to come by the office and talk to me, I can talk to you about any project. So I can't thank you everyone enough for your time. And I did notice that there was a ton of respectable participants here, and I would love the opportunity to meet with you if you ever want to call me or pick my brain. I mean, anytime. I'm the most laid back guy you've ever met. You know, obviously one of our specialties is construction defect litigation, and we do those on a contingency arrangement. And I'm pretty passionate about that, especially now, because there used to be a statute of repose in Florida where you could go after the developer and contractors up to 15 years. And the building lobby was successful in getting that changed to 10 years. And we're going to try to get it back to 15 years because a lot of these latent defects don't show themselves within the first 7 years, and sometimes even after 10 years. And if you have a community or any project that you've done that is less than 10 years old, or a new community that's less than 10 years old, you owe it to yourself to chase those developers or contractors that have done that job. And if there's a latent defect that was hidden, or you just didn't discover it until, you know, well after, within that first 10 years, then we will take that on a contingency and pursue them for money and get the money back in your pocket that you rightfully deserve. We just got a settlement in Orange County for a townhome community, which was the largest settlement of any townhome community in Florida to date. And these people were ready to go forward on a second painting contract because they thought that that's how they were going to seal the water from coming in through the windows. And that, you know, they were wrong. And now they're very happy because they just got a ton of money. So, you know, please, I mean, I don't say that contractors intend to build something sloppy. They just have, I mean, these major builders, MI, Lennar, Pulte, they are so swamped with work, they don't have time to go around and check each and every transition and check the framing and check the waterproofing. I don't think that they intentionally build a bad property, but they owe you to make those repairs, and we will pursue them for that money, and we'll take them to trial if we need to.